Добрый день, я приветствую вас, уважаемые коллеги.
Dear colleagues, good afternoon. I would like to welcome you here because I believe we're all colleagues, and since we're colleagues in profession, we're also colleagues in the common destiny that defines this profession, and that's when the profession defines or determines your destiny. So Machiavelli, whom they usually dislike to quote, said if 50% is where the destiny determines what happens to us, the remaining 50% is as where we determine our own destiny. And in fact, since I'm a deformed professor, I prepared a lecture for 2 academic hours, and then I was told that that was not the right thing to do. I had to adjust.
Таким образом, я хотел сказать, что точное название того, о чем я хочу с вами поговорить, называется немного чуть-чуть.
So the exact name, the exact title of what I'm going to talk about with you is somewhat different from the way it is declared at the forum. It's the right of force and the force of law. I hope you do not mind that much for this adjusted, amended title of my paper. At all times, whenever I started any kind of discussion, I always started it with a metaphor, and I believe it's going to be proper to quote the following one. This somewhat reminds one of the postmodern features of Alice Through the Looking Glass. There is a type of behavior whereby you can say that the execution takes place in the morning, and in the night of the same day you have the sentence announced. And that's exactly going to be force without the law. Now, if you shift it entirely and transform it, it's going to be just the right thing. However, humanity has gone a long way to accomplish the latter, and we're still in the state which was very successfully described yesterday by Dmitry Medvedev, where he was quoting Rudolf von Heering. In fighting for the law implementation, you have to fight. So the opening goes, in a fight you get your own rights, and in fact that was the slogan they used in 1917, and the very point of the statement is multifaceted, as is multifaceted the whole destiny of the law and of the rights. Now, the issue of correlation between the law and the force is the keynote one for the global thought and practice, and the great importance this issue has gained now, because in principle it is the resolution of this dichotomy that determines the destiny of the humanity as the civilization of law. We are living in a time of change, and in fact the legal systems, the national and international ones, are dragging behind tremendously badly, trying to catch up with the changes. The outcome is not only the creation of the soil and foundation for multiple legal collisions and conflicts, but also the regular cases, so when the global and domestic processes get beyond any kind of law. And this means they get outside the law, they get into the space where the dominating right is the law of force, and in fact it is the antonym, the opposition of law as measure of freedom. And that's where I would like to focus in my presentation. In the first place, I'd like to say a few words about this special feature of the contemporary time or era of change. This has to do with globalization, we all know that. This has to do with the issues that make social scientists implement what was devised by experts in natural sciences. In particular, these are issues of synergy, the theory of catastrophes, but the whole feeling one gets, and I don't want to hurt lawyers because I personally believe I am a lawyer myself, law is dragging behind understanding the legal framework of these changes. And in fact, there is no way to say that this dragging behind the turbulence of the domestic situation today is what lawyers themselves are to blame for. Why? Well, because lawyers, and I'm not afraid to state this, are a very conservative caste. In fact, they have to be moderately conservative. But the major point is not this one. The major point is that they are children of their time and of the society they live in. And therefore, those who manage to jump out of this box become heroes only after their destiny or their fortunes have been exhausted and come to an end, which usually is a bitter end. Therefore, in relation to this, we need to note some major trends in the development of law and its correlation with force and with the fight for an unlawful resolution to issues that we oftentimes, every minute of our lives, witness. This does not mean to say we're not successful. I don't want to be taken in a most straightforward way. I'm not that pessimistic. In fact, there is signs, the sun shining over our heads, and I'm only making a point of this because much has already been said about the accomplishments, and there are some challenges we ought to highlight nevertheless. In the first place, I believe I ought to note that law is not some kind of formalized regulations detached or dissociated completely from reality. This looks like the real state of things. However, consider the textbooks, the manuals published for the students when they talk about law, the rights and the correlation of law with other regulators. They always state that law is different from morality, from ethics. Nevertheless, the law is part of the social regulation in a broader sense, and in the first place, I believe it is about the connection of law to the moral, ethics-based regulations. Hammurabi, Magdeburg law, the Code of Napoleon, I'm not talking about the civil code, all of these were based, anticipating the further changes that would come next. But they really got rooted in the soil that was perceptive to them. So, considering the fact that St. Petersburg is to the north of Venice by default, I believe it is difficult, nevertheless, to go in November floating in a gondola on the Neva River wearing a t-shirt and the shorts. You can do it in Venice, though. I'm not saying this to be too complimentary of Venice. It's just because there are so many different things that you ought to consider. And in these terms, I believe when we talk about the construction of our successful future, and be sure that it be based on law, and this was stressed in all the presentations delivered yesterday, to a lesser or greater extent, we ought to very substantially research into the formula of social and cultural identity of the nation. And that's where I would like to note that, of course, we're living at a time when we've got to tread on the soil of respect for human rights. Our constitution prioritizes human rights over everything else, but at times they talk about the absolute priority, but I might be wrong in getting this, but it's about the priority of the rights of a human being for the state. Now take human rights at large. It will become obvious that we oughtn't to reach extremes there either, because a human being lives in this society and has got to be respectful of its customs, laws, traditions, and to share what is due and what is accepted. It may be very reactionist. In fact, it may be very old-fashioned, and then human rights ought to be protected. And in fact, humans have stepped in this path as well. However, we ought to remember that the society is where certain moral and ethical standards apply, and these develop. They do not stand still, where the individualistic personal rights are focused on and stressed as the paramount priority. Now, get me right, we're now not talking about the protection to individual rights of an individual human being. We're talking about the protection of the rights of the minorities, relying on different criteria, and about the protection by the social majority. And what is behind the social majority is usually stipulated through a political union, that is the state, and then further into the system of laws. Today we focus on ensuring that tolerance is the driving force, and this is deeply rooted in the previous humanity's sufferings. However, tolerance may mean that the society should not defend and protect the existing morality of what is due based on the human nature and the nature of the human civilization, then I do not think it's going to be correct and proper. In terms of family and marriage constructs, they live different lives in Moscow, in Amsterdam, in the Arabic countries, in China, and we cannot really say what is more progressive, polygamy or monogamy in other countries. In Europe, they say, can we use these terms to say that what's happening in the Arabic countries is unacceptable and disgusting? Well, no, the history will then take this track, but we believe we ought to rely on what is acceptable for humanity at large. And on this path forth, I believe tolerance should not be taken to the extreme whereby they destroy the traditions and standards accepted generally at specific stages of the societal development. The constitution of Russia, as any constitution of a state where you have rule of law, we have equal status of all citizens. It's equality before the legal justice, equality regardless of the ethnic and national origin and any other features. However, it's obvious that should this society, instead of starting a witch hunt, instead of tolerating the minorities, could do everything to ensure that the conditions are created for this in order to promote all of this instead of the traditionally accepted ones, I believe this would be a significant bias, and this is true of any minorities. It's about gender and national, ethnic minorities alike. So if you were to ask me, remembering yesterday's comparisons we heard from this stand regarding Eurovision in Austria, for instance, I do understand Mr. Minister wanted to stress the openness of Austria, and he was talking of what great luck and joy it is for Austria to have Eurovision, which is perhaps the best of the best. And informally I said, Mr. Minister, this is true, this is correct by all means, but there is another side to it, because there are people like myself, and I believe the very best in Austria is not Eurovision, but Vienna and Strauss. And in this sense, I believe we're all different, and we ought to tolerate one another, but we have to follow some track developed by the humanity as socially due and socially acceptable, and only this can be a proper foundation for the system of law, because otherwise all the norms will be rejected. In the joyful St. Petersburg, where we also at times have sunny days, if Polina Gagarina or Conchita Wurst came over, I would opt for Polina Gagarina, but as a lawyer, as a human being, I would not let them beat up those who go to watch Conchita Wurst. Another issue emerging due to the features and characteristics of the globalized world we're living in today, and the changes in the legal systems that I believe affect the very roots, the very origins of the implementation and the existence of law, is the correlation of state sovereignty and international law. In a month from now, we will have the anniversary of the formation of the United Nations. It's 70 years anniversary, and it is really a great accomplishment of this organization that after it was founded, we have been living without a total paramount war, although we have witnessed the local wars, and in fact previously our speakers reminded us of this as well. But unfortunately, the United Nations did not resolve all the issues, and they are all extremely relevant and pressing under today's conditions, in particular, among others, regarding the emergence of the international organizations, which are non-state organizations coming out to the international arena, claiming to have their own law, their own rights, instead of the law of the state, in fact replacing it. And there is no way we can disregard this, and we ought to take up this issue and consider what we ought to do then about the state sovereignty, because this was indeed the principle that underlay the foundation of the United Nations and its charter. In fact, many times I've had to say that however broad the palate's views on this issue may be, however contradictory these may be, because one worldview can lead towards the assembly of the whole world under the leadership of one train of thoughts, and the other one, the contradictory one, may lead to an entire self-isolation of a state from other ones. I believe the very idea behind the Charter of the United Nations is to interpret the issue of sovereignty not as delegating the sovereignty to the United Nations and rejecting one's own sovereignty by a state, because the United Nations was established as an organization as truly United Nations. It's more of a focus on talking about the united sovereignties in the English-speaking publications and areas. It's called, as I've just quoted. So this means that Russia voluntarily accepts the commitments listed in the international papers and keeps to itself the sovereign right to ultimate resolutions and decisions in line with the Constitution of the Russian Federation, should there come conflicts and legal collisions. I would like to be taken properly in this audience and to be understood correctly. I know Article 15, Part 4 of our Constitution and all the impact it has, and I stress that Russia by all means ought to comply with the international agreements, because otherwise there is absolutely no way we can build on the rule of law, and no way we can act lawfully. However, Russia signs and ratifies specific treaties and agreements, in particular multilateral ones, which include the European Convention on Human Rights and the major freedoms, or for instance the Charter of the International Criminal Court, which Russia signed but did not ratify, like China and the United States, for instance. So the question emerges here, which is as follows: these norms are quite abstract. In fact, they are way too abstract. In the European Convention on Human Rights and Freedoms, they talk a lot about political prisoners. In the 50s, when it all started, when they emerged the pan-European field for this issue, no one thought about taking the political rights and granting them to those who are serving their sentence in prison with a sentence imposed by the court. However, at some point of time, the European Court moved in a somewhat different direction, and we have now some fundamental decisions, some fundamental resolutions of the European Court which affected England, Great Britain, and then regarding Russia, where they stated that in the contemporary society, the article of the relevant convention, that is the protocol, where they stated the right of the people for common popular elections, the prisoners that are serving their sentence based on the resolution of the court did not have a right to vote. Well, I will not tell you what England offered as a reaction to that. I believe the lawyers in this audience roughly know what it was like, but what happened in the Russian Federation and the Constitutional Court experienced this is as follows. You see, the thing is, in the Constitution of the Russian Federation, Article 32 of the Constitution stipulates specifically this exception, this limitation of the rights to vote regarding those who are serving their sentence in prison as sentenced by courts. Now, technically, the implementation of the decisions of the resolutions of the European Court means the following. Chapter 2 of our Constitution cannot be amended with the amendment. So in order to get this amendment come through, we ought to have referendum for this in order to pass a new constitution. Death sentence as well is a delicate issue. This is now stranded for the resolution of the Constitutional Court, and there are things the social majority is inclined to, for instance, regarding the prisoners that are serving their sentence imposed by the court. I mean, I don't want to say it's a reactionist majority, but in this audience, we know that many opinion polls and surveys have registered this specific state and bias of our society regarding these two issues. However, it's not a matter of executing or not executing the resolutions of the Strasbourg Court. In fact, regarding the death sentence, I did not mention it randomly. The Constitutional Court, based on two conventions and Russia's commitments, essentially, effectively resolved death sentence would not be possible and feasible in this country. However, per the rights of prisoners, we could not get this done because based on the Constitution, Russia ratified the convention when this article was in place, and Russia did not change its constitution. This gives us grounds to state that not the convention itself, and in fact there is nothing wrong with the convention. We've got to be thankful to those who came up with it, who were inspired and who launched it across Europe, hoping that it would not range from Lisbon to Moscow, but that it would extend from Lisbon to Vladivostok. In 2005, they used to say this and to formulate it in this way. I no longer hear these statements, so I believe the development might have taken the reverse path. And in this sense, the 47 wise men that interpret the convention that does not have any specific statements should indeed think about what I started my address with, that is the social grounds for the law, the national law, as well as the international law. Should you not put the seeds into the favorable soil, they will be rejected. It's just the same as human organs. get rejected when they do grafting, transplantations. You know, Mr. Rockefeller had an opportunity to had his heart transplanted 4 times, but not everyone has this opportunity, and not always does it work out. And the first failure may indeed do a tremendous job to discredit the whole issue. The Constitutional Court, I want to stress here, we did not invent ourselves. I mean, this was stated by England, first by Germany, in fact, then by Austria, by a number of other states. But perhaps what is possible there with regard to Russia is seen with a different attitude. I'm talking about the system of orienteers. I do not want to give my assessment and evaluation of how they acted there. The Constitutional Court acted in a similar way. We formulated a legal standpoint. The convention indeed is a constituent of the Russian Federation. It's an integral part in our system, in our legal system. Indeed, when you have a contradiction between the law and the international agreement, the international agreement applies. However, the priority cannot extend further than this, as stated in the Constitution. So we concluded that if the interpretation of the Convention with regard to a specific situation, be it a discussion of whether or not the prisoners have to have political rights, in fact, is evaluated by the Constitutional Court in terms of the following. If the Constitution is there to protect the balance, the equilibrium of the constitutional rights and interests in the Russian Federation, should be given a priority. And I think there is nothing humiliating for us or for Strasbourg in this, because considering the delicate nature of this issue, indeed it was not random that the resolution was taken twice in exactly the same way, you know. Yeah, no, unfortunately I didn't have time to extend on this. I'm referring to the resolution of the German court. In fact, no one will ever say that that's the court living in some horrendous country, working in a state where the rights are not respected, and that this court is getting way too out of the proper legal practices. In fact, I believe should there be a legal collision, I believe there should at all times be a dialogue to negotiate the settlement to this issue, considering that the 47 wise men do not have the government or the lawmaker above them. And this is different from the way things are with the Constitutional Court, because the Constitutional Court does have a tremendous amount of authority, and nevertheless we remember at all times that there are senators. They've come over to listen to what I'm going to be saying about the senators, only the good things, you know, only the positive stuff. And the deputies of the State Duma, the distinguished ministers and governors, and the rest of it. The Constitutional Court lives within a system of authority and within a system of space. History will make its judgments on who's right and who's wrong. We've at all times said that the connection between the Constitutional Court and the Russian law and the European, the pan-European law, including the European Convention on Human Rights and Freedoms, and all this interaction is not a one-way bridge. It's a bridge where the traffic goes both ways. And in fact, going back to the first message I left you with, I would like to reiterate that if the legal system does not consider the social, regulatory foundation, the moral, the ethical foundation of a society, nothing constructive will come out of it. I'm not talking about the secret crucifixion dispute in Strasbourg. Let's take the French case, which essentially made the society burst, where the cartoons of Prophet Muhammad led to the intensification of the tension. This indeed goes to demonstrate that human rights, the legal self-regulating in our days is a very fragile thing, and we ought to be very careful, attentive, and sensitive about making sure that this fragile thing or substance called the rights or the law doesn't get disrupted. In fact, it's very easy to go from lawfulness to lawlessness. Locomotive is an outstanding thing, and at the time of hearing, it already was there in existence. Now, take the locomotive. If it does not have a right, a law to abide by, this locomotive will have behind it a whole sequence of crimes with the natural impact and consequences. And therefore, the combination of force and law, force and rights, is really a very important subject when we talk about the relationship between sovereignty and international law in criminal justice. I have already mentioned that there is the International Criminal Court, a very esteemed international organization. We signed the Charter of the International Criminal Court. We did not ratify it. Many countries did, though, and in fact, it's functioning. Now, what's the issue here today? In no way do I want to doubt the fact that crimes, especially the horrendous crimes against human beings, against human rights, executed by the authorities, by the power, or with their compliance, with their contribution, should remain unpunished. Well, no, of course, punishment should be penalized, but of course, it's a matter of turning to the international community. However, there is a range of issues without a resolution to which you can easily go off and outside the legal track. Now, what makes the experts reluctant? It's the attempt at extending the charter to the countries, the states that are not members of the International Criminal Court. And here you have the following a challenge. How do you go about the constitution of the state, about the constitution and its correlation with the international criminal law stipulated in the charter? That's one major challenge. And the other one is relevant in particular with the celebrations of the 70th anniversary of the victory and then the 70th anniversary of the completion of the Second World War. We ought to remember that we're also celebrating the 70th anniversary of the Nuremberg Tribunal. And in fact, we had a major fundamental lecture on this by our Deputy Prosecutor General. And those of you present in this hall, I believe, attended this lecture yesterday. No one denies the significance of this tribunal. Nevertheless, in this audience, I would like to stress that this was an extraordinary and exceptional situation where they had a conflict of forces, and in this fight of different forces there happened something described by our historian Valery Zorkin, sounded as follows: rarely, very rarely, exceptionally, using the modern language, you have to deviate from the law to preserve its force. And this is what happened in Nuremberg Tribunal, when against the atrocious crimes in that specific situation, the Allied forces deviated from the normal setup. This deviation was manifested in two major positions: null and crimen, and that there is no crime, no punishment without an indication to punishment in the law, and that no one can be a judge in one's own case. I fully agree with the experts of a pretty substantial professional level who say that in the practice of the international criminal justice, there is a trend towards implicitly, if not formally, taking the legal stance of Nuremberg. And with all the significance the tribunal had, I believe we should not automatically extend it to the contemporary situation when you have the international community, when we do not have what was going on at that time in this horrendous melting pot there. Were extinguished dozens of millions of lives. Every tear, every child, you remember this quote from a great Russian writer. But now the thing is, when you defend this child so that he doesn't shed a single tear, you at the same time end up in getting the entire world end up in a horrendous catastrophe. And in fact, I'm talking of the international laws application in criminal cases through the prism as its correlation with the Constitution and with this charter. We will to consider this. Now, if the Constitutional Court, and since the Constitutional Court does not check on this, as a judge I can say the following: even if Russia were to ratify this charter, there would immediately emerge several stances of the Constitution. Article 61 in the first place, the well-known one, which prohibits that the Russian Federation extradite a citizen of a different state to a different state, and a victim from Russia. In fact, they can well tell me that that's a very narrow case, but the Constitution altogether talks in constitutional terms, and in this sense it would be really very ambiguous if against the regulations Russia would extradite a citizen who was sentenced by this court. I'm not talking about diplomat sovereignty. I'm not talking about the immunity of the president, the deputies, the judges. I mean, there are lots of things that emerge that get us to consider the fact that these institutions are subsidiary, which means the state turns to them only when it states its agreement to participate in them, and when it can no longer deal with the case single-handedly, it then turns to these institutions. However, then inevitably there arises the following issue: the Constitution should not prevent this from happening. We know when the European Treaty was concluded, when the European Constitution did not get through, when the Lisbon Treaty was concluded, many countries of Europe changed their constitution in order to coordinate this, because otherwise how do you coordinate the sovereignty of a nation, the legal sovereignty, the sovereignty of the people, in such a way that the government or the parliament, against the stances of the constitution, could change its essence? Do you have any more time? Well, if I have some additional time, in violation of the time slots allowed for all the points I wanted to make here, although I did study rhetoric in my faculty of law. In fact, I believe they no longer teach it. So regarding the law, rights and force, I would like to mention also the following: the correlation of the public force, or the government's force, or the strength, the force of the governments in legal disguise, and about the changes in the legal regulating. In the first place, colleagues, this relates to Constitution, because the Constitution, as the major law, stipulates the most critical norms and standards regulating this. I believe it's important that I note the following: if we support the points made in the constitution. The lawyers cannot say an unconstitutional constitution or an anti-constitutional constitution. Many times I have said this, and unfortunately in our real setup this has been the case. In the early 90s, many have claimed the authorship of this notion. Then time has gone by. They now wish to hide their authorship here, but I believe there was no reason for seeking to be the author of this, because for the first time, as a contemporary of 1993 and its tragic events, I can date back this statement to Boris Yeltsin. Because in terms of the legal justice and the justice of law, what is the constitutionality of our constitution like? Boris Yeltsin said, I understand, of course, that the speech was written for him, and perhaps this had been discussed before. It's a point that is deceptive and that only flatters in vain. It only leads to a catastrophe. Americans were far more sincere when they registered in their constitution the right for riots. However, the right for people to rebel was registered when America was fighting against Great Britain. It was fighting for their independence, and they had to assert their right for riots and rebellions. Now, in the United States, can you now put together a rebellion, a terrorist attack, a terrorist kind of resistance to the power, the authorities? Here you get a reply regarding the law. As long as you have the constitutional rights and law, you don't have a right to riots and rebellions. You know, there is this famous poem about the coup d'etats that are called revolution. Should they be successful, they're promoted to the status of revolution. Now, however different our political views may be, however different our assessment of things may be, I want to draw your attention to the following. In Russia, the revolution generated some success by all means. They will tell me the science emerged. We went out in space to explore. That's one thing, but to counterbalance it, we have several millions who died in the civil war. The cream of the nation were killed and exiled abroad. Then 1930s, then the Great War, the World War II, then the coup d'etat, then privatization going top to the bottom, and in fact it was an authoritarian privatization because it was not done through the laws, it was done through the decrees of the president. I'm not talking about reversing now the course of history. No, it's only about the fact that lawyers is a very influential caste determining the policy of the state, determining the legal framework of this policy. Indeed, can't but think about the fact that there were countries of a different kind who were not afraid to learn from others and who have taken a different track in history. I'm not talking about replicating China's path or Singapore's path. I mean, what can Russia learn from there? Perhaps only be complementary of the outcomes, like a new, the late Lekanu, whose death in fact led to our evaluating what great things he did for his country, is who I remember. And now the point he said as a great reformer is order and harmony instead of freedom and equality, self-sacrifice and cooperation instead of independence of an individual, compliance with the societal dogmas instead of the freedom of thinking. Does Russia need this? I believe this will be way too dramatic, and Russia should this be taken up. I'm not being critical of Lekanu here. I am only saying that our constitution is that of a democratic state with the rule of law, and I believe we ought to move along these lines, because we don't have a developed rule of law here. But it does not mean to say it is impossible. I'm not talking about authoritarian modernization in the sense of an authoritarian regime, because that's about suppressing the rights and the freedoms. In my book, and I'm not advocating this, I talked about elements of totalitarianism as some excesses of the transitional period, and I told you already what it was like during the privatization period. So we should not reverse the course of history. I believe we need to learn from what follows the acts of abuse, of violence, in a big, emotional, sentimental country as this one. We ought to act differently. There will be then no excesses of privatization, and our today's horrendous situation would not be as is when we have 10% of difference, when we have the official difference between the 10% of the poorest and the 10% of the wealthiest ones, reaching 16 to 17 times. I mean, it's a 17-fold difference between the two categories of the citizens. So correcting this with the use of law, we ought to go ahead and not get stuck in this eternal cycle of violence, the attempt at standing still. This attempt doesn't work, and then we move on to violence. I was talking about a donkey running around in circles, but human beings develop differently. Please, the colleagues, never write speeches like the speech written by my colleagues, where they blessed what was blessed. Thank you. Dear Professor Zorkin, thank you very much for this traditional address to this forum. Everyone will confirm that this is an event everybody is looking forward to for the whole year. However big our audience is, we cannot provide sufficient seats to accommodate everyone. And right now, the audience that was viewing your address has already exceeded 7,000 people, and it's only those who registered online right away. Why didn't you tell me that from the very beginning? Well, thanks very much for this address. Thank you for this outstanding gift you made to our speakers, moderators. You are presenting your book to them. That's a great honor and a great joy for us, and we hope and we're looking forward to our continued cooperation with the 6th International Legal Forum. So is that it? Is that it? Carry on speaking. Dear Yelena, I would like to cordially thank you. I knew you were going to say this because you are a very delicate person, in spite of what my speech was going to be like. So I'm really overwhelmed with this huge audience listening to me online. Prosecutors say, get a seat. And I usually say, well, no, let's do that together. That's a play upon words. So thank you very much for the translation of my book. Thanks very much for the advertising you've done in English. And I've always told my colleagues this is the last book I'm working on, but after every last book I complete, there comes out another one. Mysteriously, perhaps thanks to Yuri, our patriarch, Yuri Tolstoy, who always brings me a poem. It would be nasty to quote, but every poem he brings me essentially has a message of that I ought to reply. And since I'm not a poet, I reply in prose. And unlike Mr. Jordan, I know I'm writing in prose. Thank you. that's been a great honor and a great responsibility for us. So we're looking forward to your next monograph for translation. Well, Russia is not only a European country, it's also an Asian state. And in fact, it's not random that I mentioned the space ranging from Lisbon to Vladivostok as a European by origin. Although I was born in the Far East, although I never lived there, I will complete using an Oriental statement as well, this one.